My name's Bill Rice, for those who don't know me. I'm one of the co-directors of the Native American Law Center and professor at the University of Tulsa College of Law. And it's been my pleasure to moderate our final panel today, the final and third panel that we have, which is simply about law and culture. We have, again, I think, three of the biggest hitters that we could possibly have asked for to be here today. Well known each and all, and I hope you will join me in welcoming our panelists for our final panel. After this, we have some time built into the program for you to tour the Gilcrease. I think they have a guided tour that will be starting after our panel is done for those who would like to have a guide, and for those who just want to wander around and look at the things that are on exhibit. I think there's plenty of time to do that before we pick back up here later. Our first panelist is Christian Carpenter. Professor Carpenter teaches property, Indian law, Native American and natural and cultural resources at the University of Denver, the Sturm College of Law. She received a BA from Dartmouth College and her Juris Doctorate from Harvard Law School. And following law school, she clerked for the Honorable John Porfirio United States Court of Appeals in the 10th Circuit. And she practiced corporate law and litigation in several other firms and specialized in several firms that practiced Indian law. She joined the full-time faculty at Suffolk University Law School in 2002, moved to the University of Denver in 2004, and I'm now informed that she is moving to the University of Colorado this June. So she has a new gig. I hope all goes well for you there. She has done remarkable work. Her research focuses on real property interest of Indian nations. She serves as secretary to the Colorado Indian Bar Association and faculty advisor to the DU Native American Law Student Association, and is involved in several community organizations there. So help me welcome Professor Carpenter as she presents her paper, Indian Law Reflections on the Law and Culture Movement.
Thanks for the kind introduction, Bill. It's great to be here. I want to thank Judy Royster and all of the people at Tulsa Law School, and also the Gilcrease Museum, which is starting to be a special place to my family. My dad donated in the last year the beautiful crystal eagle that you might have seen on the way in honor of my grandfather. And we really appreciate the museum taking such beautiful care of it, and we were really happy to see it. This is also a particular honor to speak today because there are a whole bunch of my family members in the audience, which doesn't usually happen when I give an academic talk. And I thought, unlike I usually do, I'd start a little bit more personally and talk about them. I grew up in New England, but my extended family is here in Oklahoma, where my grandfather was born and raised. And as I think about the reasons why I practice and write in federal Indian law, it has a lot to do with these relatives, many of whom are Cherokee and Creek tribal members or descendants. When I was growing up, my idea of Indian culture was largely formed by my grandfather. His constant stories of his childhood here in Oklahoma, the stomp dance tapes playing in his car, and Jerome Tiger paintings on every wall in the house. When I was 10, we first came here to Oklahoma. I got to see where my grandfather grew up in Porter, connect the stories of frying squirrel and picking cotton with a real place, and most importantly, get to know my relatives. They took us fishing on Greenleaf Lake, to our great-grandfather's grave at Fort Gibson, and the Cherokee Heritage Center in Tahlequah. My cousin Jeff, I don't know if he's here yet, they're saying no. My cousin Jeff really was taking advantage of his naive cousins from the East and killed a rattlesnake in front of us, and we were, horrified. In any event, it was a lot of pretty exciting stuff for a kid from suburban Massachusetts. And so several decades, many visits later, I'm now completely immersed in the field of federal Indian law, but still aware of the fact that my professional life owes a great deal to my family here. When I was in school, my cousin Vicki and I were just talking about this. She was writing to me about her work as Director of Community Services for the Muskogee Creek Nation. Not too long ago, I was telling our cousin Bill about my research into issues of Cherokee language and treaty interpretation, and he told me that his mother had spoken Cherokee during her lifetime, something I hadn't known. And I guess this is a long way of saying thank you to all of you for being here and taking care of my baby during my talk. And it's humbling to address this topic of law and culture in this setting. And so getting to the academic part, which is hopefully somewhat related to these remarks, I'll talk about, as Bill said, the law and culture movement and what it might have to offer the field of federal Indian law. And I'll spend my remaining 15 minutes, you can cut me off if I go too long, making 3 points. First, providing a short introduction to this movement, law and culture. Second, noting some of the cultural dynamics of federal Indian law. And third, discussing how law and culture scholarship might serve Indian communities a little bit better than it has in the past. So the first point, law and culture is a long-standing line of legal research premised on the idea of a meaningful and revealing relationship between a group's culture and its legal rules. In classic works of legal anthropology studies, scholars studied so-called primitive cultures for indicia of law, despite their lack of obvious legal institutions. So there's this famous work on the Northern Cheyenne revealing that that community had customary rules fostering the kind of cooperation among group members that was essential to their hunter-gatherer society, and finding that the Northern Cheyenne, shockingly enough, had law reflecting their culture, even if it didn't resemble Anglo-American legal norms. In recent decades, the law and culture endeavor has evolved somewhat so that researchers aren't necessarily pursuing field research to uncover law in a culturally different other. Rather, the prevailing assumption is that law and culture are mutually reinforcing phenomena in all societies. And so contemporary scholars examine the ways in which law informs culture and culture informs law, with the goal of better understanding these forces that shape human existence. And so an example, in considering Americans' attachment to the Bill of Rights, law and culture scholars would note that our cultural commitment to liberty and personal freedom probably explain and inform why this ancient document remains so critical to our way of life today. And when we face difficult legal decisions about how to interpret a principle like the freedom of speech or right to bear arms, we shouldn't focus on any particular abstract rule of law, but consider how it will function in our cultural context. Federal Indian law rarely appeals in an explicit way to this substantial body of law and culture research. And I think this is a curious thing because most Indian lawyers would probably agree that an appreciation of the cultural dynamics of Indian law is essential to their work. Historically, Indian law advocacy developed to counteract the federal government's efforts to eradicate tribal cultures and assimilate individual Indians into mainstream America. My co-panelist, Allison DeSias, has written really evocatively a lot about many of these practices, including outlawing Indian religious ceremonies like the Sundance in the 1890s, breaking up collectively held tribal lands through allotment here in Oklahoma, forbidding Indian children to speak their languages in schools, building Christian missions on reservations, relocating entire Indian families to urban areas in the 1950s, and on and on. The federal government has, at least since the 1970s, denounced these earlier policies, but tribes continue to experience what we might call cultural challenges in contemporary legal battles. And these are somewhat unique to Indian law. In fact, in cases outside of Indian law, the distinctiveness of regional histories, values, experiences, what we might call regional culture, is often cited as a justification for state and local governing rights. And my other co-panelist, Alex Skabeen, has argued that a preference for local governments and associations is a key aspect of the federalism concerns so pervasive in the Supreme Court. What this means is that we want states and citizens to express different cultural values in the laws that govern their daily lives. And so states have considerable latitude over things like criminal justice, to have a death penalty or not, family law, same-sex marriage or not, taxation, whether to tax sales or income, land use for conservation or development. I could go on, but these are differences in state law that surely reflect cultural influences, whether historical, religious, regional, etc. As just one example, until 2004, Utah was one of the few states where death row prisoners could elect execution by firing squad, in part to satisfy a Mormon requirement that blood must be shed to atone for murder. I realize this is somewhat of a quirky example, but the point is that we are a nation that accommodates cultural differences, in part through a tradition of robust state versus federal or national governance. But when it comes to Indian law, the Supreme Court fails to apply these same principles in favor of local governance by tribes, and actually uses cultural observations about culture as a basis for denying tribal rights. And again, a few examples. Criminal law, as I suggested, is typically local. If you commit a crime in Colorado, even if you're from Oklahoma, Colorado has jurisdiction over you, and it doesn't matter what your race is. But in 1978, the Supreme Court held that if you commit a crime on an Indian reservation, the tribal government does not have jurisdiction over you if you are non-Indian. The reason, according to the court, is that Indian criminal justice is too culturally alien and culturally inferior for non-Indian citizens. This was called the Oliphant opinion. It's well known to a lot of us. It was decided just 30 years ago. And listen to some of the language that the court used to describe Indian criminal justice, writing that it operated according to the prejudices of their savage nature, without fixed laws or tribunals, appealing to the red man's revenge instead of the white man's morality. And of course, this was demonstrably true. By the time of Oliphant, the Cherokee Nation, for example, had already had a sophisticated court system, a constitution for over 150 years, as Dr. Strickland wrote about in Fire in the Spirits. But the Supreme Court's perceptions about Indian culture were enough to deny tribes jurisdiction over all crimes, where a non-Indian is the defendant. In 2001, the Supreme Court held essentially the same thing with respect to civil cases. In many cases, although there are a few exceptions, tribal governments now lack jurisdiction over civil disputes involving non-Indians. And as our now retiring Justice Souter said, this was because Indian courts could use customary law, which non-Indians might not be familiar with. So even on the civil side, judicial perceptions about Indian culture render Indian nations incompetent to adjudicate legal matters. These cases are about the powers of tribal governments. Unfortunately, cultural biases also work to deny Indian citizens basic protections of the Constitution. And here the comparison isn't to states' rights, but to individual citizens and entities' rights. And consider a few more examples. In a 1955 case, a group of Alaska Natives sued under the Fifth Amendment for the taking of their property. It was undisputed that the government had taken 360,000 acres of richly timbered land without consent or compensation, but the court held no Fifth Amendment violation had occurred. This was because the property was held pursuant to Aboriginal title. What that meant more specifically was that Alaska Native land was shared among community members, used for subsistence hunting, commemorated by oral tradition, and descended through the female line. In short, Alaska Native property was, in the court's view, wholly tribal and thus ineligible for the protections of the Fifth Amendment. And similarly, the distinctiveness of Indian culture seems to make Indians ineligible for the protections of the First Amendment and its guarantee of religious freedom. A case currently on its way to the Supreme Court, and this is one that I've worked on, is Navajo Nation versus U.S. Forest Service. This case involves the Arizona Snow Bowl, a privately owned ski resort that operates by Forest Service permit on the San Francisco Peaks in Arizona. The Snow Bowl recently requested permission to use sewage effluent, and this is just a fancy way of saying treated wastewater, in snowmaking on the peaks, and the Forest Service agreed. To the Navajo, this was a problem. The peaks have been for thousands of years one of their 4 sacred mountains, marking the boundaries of the Navajo homeland. At the time of creation, the Navajos believed it was the place where changing woman resided and gave birth to the twins who are the ancestors of today's Navajo people. Contemporary medicine men go to the peaks to gather plants for use in ceremonies. The Hopis were another tribe on the briefs there. They believe that the Kachinas, who are spiritual beings, reside on the peaks during the winter and come to Hopi villages in the spring, bringing rain for their crops. Both tribes say they're obligated as a religious matter to care for the mountain, and they can't do that if the federal government is spraying it with wastewater or permitting the private ski resort to spray it with wastewater. And their ceremonies won't work if the natural waters and plants on the mountain are contaminated. The president of the Navajo Nation went so far as to call this genocide. So for these reasons, the tribe sued under the First Amendment, but so far, the lower courts have found that the government's action doesn't substantially burden religion under the First Amendment or the Religious Freedom Restoration Act. These cases follow an earlier Supreme Court decision, and I think Dr. Phelan mentioned this. It's the Ling case, where the government held that, where the Supreme Court held that the government could actually destroy a sacred site and destroy an entire tribal religion without violating the First Amendment. This is kind of worth pausing over. Imagine the Supreme Court holding that the government could virtually destroy Christianity or Judaism without violating the First Amendment. And in fact, it isn't just Christianity or Judaism. The First Amendment regularly protects minority religions. Wicca, Asatru, Santeria have all been protected in recent Supreme Court cases. But in the Indian cases, the Supreme Court says it would be impossible for the government to operate if it had to accommodate the religious beliefs of all of its citizens. So I'll stop reciting federal Indian law cases now. The basic point is that judicial perceptions about culture seem to deny Indian rights in many cases. And yet, as I suggested earlier, a preference for cultural pluralism seems to support local governance and individual rights outside of Indian law. So the question I'm trying to examine in this research is whether law and culture scholarship can tell us anything about why Indians are uniquely disadvantaged by their culture in legal cases. We could examine Navajo Nation like the old legal anthropologists. Unlike other religions, the Navajo religious practices don't occur in a church or a mosque or a temple. They're outdoors in the natural world. They don't derive from an authoritative set of legal principles recorded in the Bible or Quran or Torah, but they're kept in oral traditions. They're less about individual religious salvation than they are about the collective welfare of a tribal community. In these ways, maybe Indian religious practices are different from some of the religions that are obviously and readily protected by the First Amendment. But how different? Again, putting on that same law and culture hat, we could observe that the idea of a religious covenant mandating human behavior isn't that unusual. Christianity's 10 Commandments, the Jewish obligation of keeping kosher come to mind. Other religions obviously have their sacred places, Jerusalem, Mount Sinai, Mecca. Viewed in this light, Indian religions just don't seem that different from others often protected by the First Amendment. Or we could take the more contemporary law and culture approach, evaluating the problem as one about, instead of looking at the problem as one about a culturally different other, we could look at these disputes as illuminating the law and culture dynamics of the majority and minority societies. Indeed, the Snowball case probably says as much about our American culture as it does about Navajo culture. We're talking about a medium-sized ski resort located in the desert that has hardly ever in its existence turned a profit. With the benefit of this proposed sewage-enhanced snowmaking, the Snowball could offer a few more ski days and enhance its revenue by a few $1,000s. I'm a lifelong skier, and I'm not very religious, but I have a hard time seeing how snowmaking could possibly justify the destruction of an ancient religion. And I wonder why we as Americans, perhaps culturally wedded to capitalism, have come to prioritize marginal wealth maximization over the freedom of religion, particularly in a country where religious liberty is such a defining element of our national identity. And what about the ostensibly foreign nature of Indian property? Looking back at the Tehitan case, for example, you might observe that Alaska Natives are not the only people in America who sometimes use their property for hunting or let their neighbors visit or pass it down from mother to daughter. They're not even the only people in America who own property collectively. The entire model of the corporation rests on the idea of distributing the company's property among shareholders who sometimes number in the thousands. Surely the Supreme Court isn't going to suggest that corporations are culturally suspect or unentitled to the protections of the Fifth Amendment. We could also apply law and culture analysis to those criminal and civil jurisdiction cases I mentioned earlier, and here perhaps there are issues of cultural difference meriting some attention. In some tribes, criminal violations are addressed through restorative justice instead of punitive sentences. Taking just one example, in the domestic violence arena, some have argued that allowing batterers to remain in the community instead of in jail leaves women and children insufficiently protected. On the civil side, some tribes recognize membership along patrilineal or matrilineal lines that seem to conflict with American notions of equal protection for both genders. So we might want to ask in an explicit way whether those cultural differences so conflict with American legal norms that they require some creative solutions to promote contemporary notions of justice. And from the perspective of a tribal advocate, I think that a narrow focus on these kinds of cases and the specific cultural differences in them might be preferable to a blanket denial of tribal jurisdiction that the Supreme Court seems to apply in case after case. So the remaining question, and one I'll explore in more detail when I write this paper, is why law and culture scholarship, for all of its nuanced observations about cultural dynamics elsewhere in the law, hasn't been too useful in federal Indian law and how we might improve it in the future. Taking just one example, Naomi Mezzi is a prominent law and culture scholar. And she's not particularly interested in the problems of American Indians, but she's written a series of articles using Indians as an example of her theory of cultural hybridity. In her view, culture is not static or well-defined, but messy and always evolving. Culture evolves through exchanges such that each group borrows something from the others. And you heard other panelists talk a little bit about this theory of cultural hybridity. Mezzi, Michael Brown, others, Anthony Appiah, have pushed this forward in the literature. And many of us might agree with Mezzi and these other scholars up to this point. And this idea of culture as a cosmopolitan product of the entire world is quite popular. It's also intuitive, something we see in daily life. American jazz comes originally from African music traditions. Our American cuisine now seems to include everything from spaghetti to sushi. Even the Statue of Liberty, Angela had the panel up, comes from France originally, right? Yet all of these have been somehow incorporated into the American experience, perhaps blurring cultural origins in some cases. But I can't agree with the punchline of Mezzi's argument, which is that as a result of hybridity, there really are no distinctive cultural identities left, and thus no legal claims that would be justified by distinctive cultural identities. In the American Indian context, for example, she argues that because Indian sports mascots, no matter how offensive, developed in football stadiums rather than in tribal communities, there is much the concern of white Americans as they are of Indians. And because Hopi society has changed over the last 100 years, such that Hopi kids now listen to hip-hop music, Hopi people have no claim to cultural objects stolen from their communities generations ago. And because some tribes, probably most tribes, now have mixed-race citizenship, they shouldn't be entitled to the legal provisions entitling tribes to run casinos to meet the economic needs of Indians. Mezzi has the law wrong on a number of counts. Angela mentioned earlier that we co-authored an article this year. That article spent about 100 pages describing all of the ways in which we felt that Mezzi had it wrong. The short version is that many Indian rights arise under treaties, statutes, regulations that don't rely on any standard of cultural distinctiveness or authenticity. But even setting that aside, the long and short of Mezzi's argument sounds either like cultural nihilism or ostracism to me. Her view is that there really are no Hopis, no Navajos, no Creeks or Cherokees left today because they've all disappeared into the American melting pot. And if there are any people left clinging to one of these Indian identities, they should recognize the anachronistic nature of their attachment and start disappearing into the American melting pot. You can see how these arguments fail to serve the tribal cause. American Indian culture is either outdated or strange or doesn't exist at all. And you can see resonance between some of these theoretical arguments and the actual cases I mentioned earlier. In the jurisdiction cases, courts hold that the tribal governments can't try non-Indians because Indian culture is too strange to possibly be fair. In the religion cases, the courts seem to have a very hard time taking seriously the idea that in 2009, some Indian people still believe that their gods reside on a ski mountain outside of Phoenix. It's easier for the courts to assume that the culture has already disappeared and therefore no longer merits legal protection. So for tribal advocates, the challenge is how to use some of the law and culture movement's helpful observations about the interrelatedness of law and culture while countering its assertion that tribal cultures are either impossibly foreign or completely dead. The way to make such arguments, I think, is to pull law and culture a little bit back from its current postmodernist incarnation and recall its roots in anthropology. What I mean is that we should resist the idea that culture is both nothing and everything, important to everyone and no one, and try to provide a little bit more empirical data from Indian country about how people are really living their cultures today. We can argue, for example, that the Navajo Nation's snowball claims are both cognizable under the First Amendment and dependent on a different set of cultural values and experiences than other American religious practitioners would claim. In that case, the freedom to worship doesn't mean taking Sundays off from work. It means protecting a sacred mountain from development. And this is true even if some Navajos are now intermarried with Hopis or whites or go to Christian church occasionally. Cultures can evolve. Individual members of a community can have different viewpoints or lifestyles. And this doesn't mean that the culture should necessarily be ineligible for legal protection. Hopefully, by using the tools of law and culture a little bit more thoughtfully, we can persuade the courts to see that American Indian legal claims are important both for individual rights and equality among peoples, for the survival of Indian cultures and our larger tradition of American pluralism. Thank you.